Welcome to the League of Women Voters Mount Baldy Area Juvenile Justice presentation. This is the third program in our series on criminal justice. Previous presentations are available to view on the League of Women Voters Mount Baldy Area YouTube channel. I am pleased to present our two panelists for today. Sarah Jewett has been practicing law since 1994 and has been a public defender for most of her 29-year career. Throughout her 3-decade career, she has represented clients charged with all types of crimes, from misdemeanors up to serious capital crimes and death penalty cases, and has been lead trial counsel on over 200 jury trials. Sarah's decision to spend her career in service to underprivileged clients stems from her early life experiences. Sarah is a survivor of childhood abuse and was in and out of foster care systems several times before the age of 18. In addition to being a lawyer, Sarah has raised 3 grown children to be warriors for justice and social causes. Sarah gives back to the community through acts of service, in addition to volunteering at expungement clinics and helping people clear their past criminal records. Sarah has been a Girl Scout leader, a mock trial coach for high school students, and an active volunteer with GLAD. Currently, Sarah is a supervising deputy public defender assigned to a special litigations team. Sarah works with juveniles when they are first arrested, and she will talk today about how the early access to counsel has been instrumental in changing outcomes for some of the youngest and most vulnerable members of our community. Thank you, Sarah. Julie Neal began her career as a high school English teacher before attending law school. She has a master's degree in education. After law school, she went to work with the Public Defender's Office in 2008 and has worked in the juvenile division as well as adult felonies and misdemeanors. For 8 months in 2020, she worked for the California Office of the Inspector General as a Special Assistant Inspector General. She returned to the Public Defender's Office after realizing she wasn't done advocating for indigent clients. For the last 5 years at the Public Defender's Office, she has been the team lead for the Juvenile Division and has litigated transfer cases, and has served as lead for foster youth clients, clients going to probation placement, clients in the mental health court, and clients placed at DJJ, and now clients placed at the county level secured youth treatment facility. Her legal claimed fame is in the In Re DC decision, the first published case on human trafficking defense. Her client's adjudication was reversed on appeal, and the appellate court found that the trial court should have found the client not guilty based on the trafficking defense. I am so pleased to have both of you here with us today. Following Sarah and Julie's presentation, we will have a Q&A. Please feel free to place questions in the Q&A function at any time, and we'll get to them at the end. With that, I'll turn the time over to Sarah and Julie. Thank you so much.
Thank you, Rachel. Thank you for having us today. I really appreciate that. Being able to talk to everyone about the work that we're doing at the Public Defender's Office. I wanted to start by talking about what a 395 phone is, or what Senate Bill 395 is. So Senate Bill 395 basically gives access to juveniles, to anybody under the age of 18, before they can waive their rights. So before they can make a statement to law enforcement is supposed to give them access to counsel. And I'm going to talk a little bit about some of the challenges that we have with providing that access, and some of the challenges that we have, and some of the success stories we have as well. We have a lot of success stories with working with different agencies on running this phone. But essentially 24/7, our agency runs a hotline, a cell phone, and somebody will always answer that phone no matter what time of day or night. Law enforcement agencies from all over the county will call us anytime that they have a minor. So when they call us, we are able to do a lot of things. We can avoid incarceration for the minor sometimes. We can avoid having the minor taken to the hall. Basically, one of our goals is to avoid that some of the negative social and emotional ramifications that come into play whenever there's law enforcement contact with our minors. Studies have shown that there's rates of increased depression, suicide rates, mental health rates, lower GPAs, lower engagement at school, whenever a minor has had a negative or what sometimes is called an adverse childhood experience. But negative actions or negative interactions with law enforcement is one of those key stressors in childhood that end up leading to higher rates of depression and other negative consequences for our youth population. So Senate Bill 395 tries to change that. And it does so by making sure that they have access to counsel. Access to counsel can help reduce that emotional distress that happens when they interact with law enforcement. Access to counsel can also help make it safer for law enforcement when they're interacting with the juveniles and sometimes with the families of the juveniles. For example, when I get a phone call, sometimes the family will hear in the background a lot of chaos or noise going on at the officer's side of the call. I get the call. I don't always know what's happening at the scene. The minor that I'm talking to might be in a police car already, or they might be on the side of the road. They might be in their home. They might be in a school principal's office. Those are some examples of places that they may be when I start speaking to them. Sometimes I can hear a lot of chaos in the background, and it's usually either the minor or a family member or guardian for the minor who can be very rightfully so, very hostile, very upset, very unsure of why their minor is being arrested, and angry at law enforcement. When I get to talk to the minor can, my communications with the minor is confidential. However, the minor can allow to have their family member present, and 9 times out of 10, they do ask to have their family member present with them. Law enforcement, however, has to leave the scene. So they have to leave the principal's office or the patrol car and let me have that confidential communication with the minor. When I have these conversations, communications, I can start to de-escalate the level of stress. I do that with a lot of things. I do that with my voice remaining calm, reassuring. I let them know who I am. I'm there to help them. I'm there to defend them. I'm going to give them advice on how to use their constitutional rights to protect themselves. I use words like empowerment. I empower them with using their constitutional rights to protect themselves. And throughout the process, my goal is to answer their questions, de escalate the situation so that there's less stress for them in this situation, and also to protect their legal case going forward. And obviously, protecting their legal case going forward means making sure that they invoke and that they don't make a full confession. So, when we talk to the juveniles over the phone, uh, sometimes I will ask the officer, for example, I get repeat calls from a lot of different agencies. So I get to know these officers. So I can develop more of a collaborative interagency approach with my communication with the officers. They can let me know a little bit more about the situation. Once they get to know me and there's some trust developed, they'll let me know all kinds of things that's going on in the background of the scene. For example, like what kind of investigation led them up to meeting with this minor. Some officers will even indicate whether they believe or disbelieve a particular witness that has come forward about something. And so in those situations, we are able to get the minor site released rather than taken to the hall. Let me digress a little bit here to explain some of those terms. A site release is a piece of paper, a citation. It's similar to what you get if you got a traffic ticket, if you were stopped driving too fast or reckless driving or something of that nature. You will get a piece of paper that tells you to come to court in the future. You're not actually taken into custody. It's considered a type of arrest, but it's really a piece of paper telling you to come to court in the future. Similarly, with minors, they can be given a citation, that piece of paper to tell them to come to court, or they can be taken to juvenile hall. Juvenile hall is called detention, not incarceration, but the end result for the child feels the same. Their liberty is no longer their own. They are subject to more rules. They are subject to going a specific place and not being allowed to leave until a judge allows them to leave. So I want to avoid the detention aspect. I want to avoid having them go to the hall. So when I talk with the law enforcement agencies, sometimes I'm able to talk them out of taking a minor to the hall. So calming down the situation, calming down the parents, calming down the minor, and sometimes talking with law enforcement to de-escalate the status of what's going to happen next. I'm successful sometimes in getting, especially our minors, our children of color, not going to the hall because we've had statistics show that the more often our children of color go to the hall is going to be a of high correlation with their reduced GPAs, reduced academic opportunities, and then reduced job opportunities in the future. With the Racial Justice Act, I've been successful at getting watch commanders at the various agencies to agree that this particular child is not going to go to the hall, even though based on maybe the charge or based on the child's age or some other factor, they had previously decided they would be taking the kid to the hall. But after speaking with me, they finally agreed not to take the kid to the hall. Sometimes officers that I speak to will tell me that they are calling the hall after they talk to me, after they talk to the minor and the minor talks to me. And so then I know that if sometimes I will be able to call the watch commander directly at the hall and make some special arrangements if those need to be made. Additionally, when I know that a kid's going to the hall, I can loop in other services that my department provides. For example, we have social workers. I can get a social worker over to the hall to visit that child the very next morning so that the child is not left wondering, where's my counsel? Where's my family? And we are able to then connect with from the social worker to the child and then connecting to the family to keep the family and community engaged with the child. So I wanted to kind of relay some of those things because I think that those are important for our goals of reducing the emotional distress of interactions with law enforcement. The interaction with law enforcement starts even before the officer actually starts talking to the child. When the officers are preparing to go out to a home to interview the child or preparing to go to the school to investigate something, the officers need to have the training on who to call. And sometimes they call me before they go out. They give me a heads up that there will be a call. They give me the information of what's happening. And then I can sometimes speak with them about different ways of interacting with this particular child, with this particular child's family in situations that may help de-escalate the situation that the officer is going to be in and that our child client is going to be in. When I talk with the parents and the children, I'm able to talk them through the process. So telling them what happens next is really helpful in de-escalating some of the stress and trauma of what happens when they talk with law enforcement. Knowing that what's going to happen next. The officer is going to do this. The officer is going to say that. Here is exactly what you're going to do to respond, to protect yourself. And then after that is done, then the officer is going to either write you the citation and you're going to come to court. Or if you're going to go to the hall, I will explain when their court date will be 3 days from now. Also, juvenile hall will call me as soon as the child gets there. So again, I can have another conversation with the child to help de-escalate and help reduce some of the emotional distress that these children are going through when they get to the hall. Community engagement and family visitation with our minors that are going to the hall is so important. I can give you an example of a minor who I went to a hospital to see because the minor had been involved in something that resulted in a medical situation. So the minor's in the hospital, and I'm speaking with the minor, and the minor really wanted to be able to speak with his mom and his baby. So I was able to get the child's family on the phone with a FaceTime on my own device. And they had a nice long conversation, which helped reduce the stress of that environment because the minor had been in that situation, been in the hospital for over 24 hours and had not had access to their family yet. And the family was obviously very concerned. And again, we could get our social workers involved immediately. I was able to call the family later after finishing up with the client and again walk them through the steps of what's going to happen next and how do they stay in touch with their minor who was at that point was going to the hall. So a lot of what I do with the 395 phone is the gateway to our office so that our clients and their families know that we are there for them, that we're fighting for them. It's helpful to reduce their stress because we want to protect their legal rights and teach them their legal rights as well. I find that a lot of the minors that I speak to from our entire county, some of my clients they come from a variety of social economic backgrounds. Some of them come from school districts that have high performing numbers. And so some of the juveniles from the school districts with high performing numbers, they typically get it right away. They understand the process right away. I tell them what to say and they understand it. And it's quick and easy for them to follow through and make sure that they invoking by saying no when the officer asks if they want to talk or speak to them. Other children, other juveniles from less high performing educational school districts, or some who may not have been to school in a while, they tend to have a little more trouble understanding. And so if I didn't have counsel there with them, if I'm not on the phone with them, and sometimes I even have to prompt them again while I'm on the phone, if I'm not on the phone with them, then there's a higher likelihood that they're going to end up not invoking and forgetting what I had just told them when I tell them, here's what you're going to say. And then a few minutes later, they might forget. Some of that is due to their brain development. And I know Julie's going to talk a lot more about how brain development affects the outcomes for our children, our child clients. And some of it has to do with just the education, disparities in education, as we can see in our client population, have a huge impact on the success of their outcomes. Another example is when we want to have humane treatment for our clients, for example. I will go to the scene. I want to make sure that the child is being treated properly. I want to, when the child is, let's say, in the back of a patrol car, I inquire about whether they are handcuffed. I ask the officers to unhandcuff them while they're speaking to me, because again, I want to make sure that the children, that the juveniles have their stress reduced so that they can listen to what I'm saying, that they can focus on our conversation and be less focused on the fact that their arms are behind their back and that their wrists are being pinched in the handcuffs. So as an intermediary between the client and law enforcement, sometimes I'm able to get law enforcement to, I don't know how to phrase that correctly, but basically to kind of reduce that stress, the physical stress on the client that the client's undergoing. Other successes I've had is I've been able to get law enforcement to put clients in emergency foster care rather than taking them to the hall. When a client is being arrested for, let's say, a potential battery on a family member, and the family member no longer wants the child in their home at the moment, law enforcement is faced with, well, where do I put this child? So the knee-jerk reaction for some officers and agencies has been historically to take the child to the hall for detention. But we know statistically that when children go into the hall for detention, they are more likely to go into the hall more times. A child who is sight released is less likely to have repeat behavior than a child who goes into the hall. So avoiding going into the hall is one of my priorities when I get these incoming phone calls. So in those situations, sometimes I'm able to talk officers into calling the Department of Child and Family Services and getting the kid into emergency foster care if the main reason that they would go to the hall is just because they don't have any other bed space for them. Another thing we're able to do with getting early access to care for these children, early access to counsel, is we're able to go to the scene, we're able to start building that trust with the client, and we're able to follow the client through the system. For example, had a few calls, but one in particular, this one minor was telling me about how nobody in his life cared about him. No one cared about whether he went to school or not. Nobody cared whether he graduated or not. And he just felt completely at a loose end. And without feeling that community engagement or that family engagement, he was not going to be as successful in school. With that child, I did tell him, I will be there for you. I will be at your court dates. I will follow you. And we ended up sending him some gifts for his birthday, finding out things that he was interested in, and trying to support his hobbies and things that might give him some enjoyment outside of the court systems to help him build that respect, that self-respect, and also that idea of when people support you, you feel supported and you're going to do better on a mental health basis. Those are just a few of the success stories that we've had. Ultimately, I think as we're all aware, that aggressive policing, as sometimes has statistically happened in the past, is associated with negative educational outcomes. One of the other things we're able to do with having Senate Bill 395 and running a 24-hour phone is we're able to right away talk to the kids about what's going on at school. What's your GPA like? Do you have an IEP? An IEP tells me a lot. It tells me if there's ADA accommodations that need to happen. I can ask the child if there's immigration issues that we need to address, so I can get them connected with our immigration attorney immediately. And if they do have an IEP, I have the parent bring the IEP to the first court date. The reason that's important is it avoids a next court date sometimes. If we need that IEP for negotiation purposes or for making sure that their ADA needs are met, we can get that right away rather than having a delay. Sometimes in court, when I've represented juveniles in court, and you find out that they have an IEP, but the parent didn't bring it, but you need to see a copy of it. So occasionally those cases get continued to another court date, which is really a delay in the process. It's a delay for the child who has to come out of school another day to come here. It's a delay for the parent who has to drop work another day to be here there. And it's just more interaction with the court, which again, heightens stress for the child and potential negative adverse effects for the child. So getting the IEP immediately, very helpful for us, for our outcomes, for negotiations with the DA. And when we have the 395 phone, on those calls, I ask right away, do they need accommodations with the ADA? Do they have an IEP? How's it going at school? And do we need an immigration consultation? So those are some of the ways that my department is able to meet the immediate needs of our youth population through having immediate access to counsel. And so Senate Bill 395 has been very, very helpful for that. I think I'll wait and answer questions at the end. I'm going to turn it over to Julie. I think I've talked close to 20 minutes. And I'm certainly willing to answer any questions that people may have. But at this point, I'm going to mute and let Julie speak on her part of it. She basically handles the kids on the other end when they're at court, and then some of them have been placed in group homes, and she'll talk about that process and how we assist them in their reentry after placement in group homes. Thanks.
Thank you, Sarah, and thank you for having me here. So my name is Julie Neal. Sarah and I have worked together for years and carpooled, I think, for a while too. My role is to be an actual in the court litigator with the juveniles in San Bernardino County. So I'm going to give you there have been tremendous changes in juvenile law just in the last 5 years. So I wanted to go very quickly over what it used to be and what it is now. So when I first started in 2008, the district attorney, when for certain charges, and they were, very serious things like charges such as murder and some other things, the district attorney had the option of direct filing a juvenile into adult court. And they could go as young as 14 on some of these cases. So you could have a 14-year-old facing an adult sentence in some cases, whether you agree with that or not. That was the law. Then there were some cases where the district attorney would file. There were some charges that the district attorney had to file for what was called a fit and proper hearing for whether or not that child should go to adult court. And the presumption was that the child was not fit for juvenile court. And again, I should back up a step. The difference between juvenile court and adult court is that juvenile court it's about rehabilitating the juvenile. How do we make sure that this child never sees us again? And I can tell you that my goal back in 2008 and my goal now is that this child never sees me professionally again. And that when they leave my care and me being their attorney and their counselor, that I have met their rehabilitative needs both legally, but also socially if I can. That includes school, that includes housing, that includes any social services that I can refer them to that would reduce their likelihood of ever seeing me or any criminal defense attorney again. And in my opinion, one of the things that I can do to reduce their likelihood of seeing me again is by putting in place the things that they need in their lives. So back in 2008, you could direct file and you could the district attorney could ask for a fit and proper hearing. And then we got some major Supreme Court decisions that started to recognize the developments in brain science. So what do we know from neurologists and from scientists all over the world is that, and many of you, probably all of this, we all know this intuitively, but now we can show it through evidence and through science. And a lot of this is based on functional MRI studies, is that the brains of juveniles are not the same as the brains of adults. And that the adult brain isn't really matured until you're about 25 years old. Your brain is still maturing, especially for boys. And there is research that backs the idea that female brains mature faster than male brains, which is why probably One of the reasons why we tend to see more boys, more males in delinquency court than we do females, but we do see a lot of females too. And part of the reason is because their brains are not developed. And when you hit adolescence in these teenage years, actually, one of the reasons why you see such big changes in behavior is because the brain structures, which are causing a person to be able to regulate their emotional responses to emotional stimuli, and they're changing, they're growing, and they're not okay. And so those kids they're struggling to get through their day and to make good decisions. And that's why supporting teenagers is really important, giving them lots of structure. And also we know things like teenagers in groups. You know probably intuitively as an adult that teenagers in groups sometimes make bad decisions, but we now have scientific evidence that tells us that is true, and there's a reason why. So as those Supreme Court decisions came down, and I can tell you Roper, and especially a case called Miller, those were examining issues such as, should a juvenile be imprisoned for the rest of their life for certain crimes? And as those decisions were coming down, the state of California was looking at those things, and there were certain Supreme Court mandates, and then there were just certain things that the legislature decided to change. And so the legislature changed how a child gets into adult court now. So they changed it from direct filing, no more direct files. Now the district attorney notices what's called a transfer hearing, and there are 5 criteria. And it used to be that we would balance the criteria, and the district attorney had to prove by a preponderance of the evidence, so a little over 50%, that the juvenile was not a fit, that the juvenile should be transferred to adult court. And then just recently, actually in 2023, the criteria changed again to now the district attorney must prove by clear and convincing evidence under these 5 criteria that the juvenile is not a fit subject for rehabilitation. So that has changed a lot. And the 5 criteria deal with prior delinquent history, prior attempts to rehabilitate. They deal with the socioeconomic circumstances of the child, the brain development of the child. So the legislature has very much emphasized that they want the people in court to litigate very individual things about each child that is being proposed for transfer to adult court. It's also changed, the legislature also changed that you can only children 16 and older, so 16 and 17-year-olds can be transferred to adult court, and everybody younger, so 15 and younger, cannot be transferred. Another thing that has changed, it changed right at the beginning of the pandemic, was the legislature shut DJJ. So the California Department of Corrections and Rehabilitation, that's the acronym for that is the CDCR, operates the state prisons in the state of California. There were also prisons for juveniles, and the state had been slowly shutting down the facilities throughout the state until there are only about 3 left now. They are very expensive to run, and the recidivism rate for juveniles coming out of those facilities was very, very high. And there were a lot of problems in those facilities. So some of you may remember the term CYA. So the name has changed over the years, but the legislature shut down the youth authority. So that's the kid prison. And they redirected those funds to the counties and directed the counties to come up with what are called secured youth treatment facilities. So there are now no longer any, well, it's shutting as of June this year. The DJJ will shut down completely, and any youth remaining in a DJJ facility will be returned to the county's secured youth treatment facility. And as with any new program, some counties are really blazing a trail in implementing these secured youth treatment facilities, and some counties are lagging behind. So one of the things I can tell you about San Bernardino County is that so this responsibility for putting the youth that are considered the highest level youth, but still should be treated in the juvenile justice system in order to be rehabilitated, those youth have been sent back to the counties. Our county facility is the old Apple Valley Juvenile Hall. The program is called Arise. And the youngest a youth can be to be sent there is 14. And the jurisdictional limit for a youth to be in that facility is 25. So it's a pretty wide range. Our county has and that responsibility goes to your county's probation department. So our county's juvenile probation department has worked very hard to put together quality programming, as with any government facility. And there's a lot that goes into creating government contracts. So some of the programs that we wish existed right now don't exist yet, because it just takes a long time to get contracts done. But I can tell you that our county probation department they're actually working really hard to put together quality programming. Do they sometimes have stumbles? Sure, they do. But there is a good faith effort there. There are problems in other counties. There are problems that have resulted in statewide legislation. The LA County juvenile probation system is in a lot of trouble right now, and they have not implemented the secured youth treatment facilities to the extent that our county has. So we have actually worked very, very hard. There have been a lot of stakeholders that have had a say in trying to make these rehabilitation programs as good as we can get them, because one of the things that we acknowledge for these juvenile kids with the most serious crimes is that they are going to get out of custody one day. They're returning to our communities. How, under the old system at the state level, the CYA, also known as DJJ, those kids weren't coming out with the rehabilitation, weren't always coming out with the rehabilitation that we probably would have liked to have seen for them. And so we're trying to implement the rehabilitation that I think we as local community members would want for people who are returning to our communities. So one of the things that I do is I litigate, should a youth go to adult court or should they stay in juvenile court and be rehabilitated? And I will tell you right now, I'm biased towards the idea that almost all people can be rehabilitated, and that is based on evidence and science. And basically, almost like all the research says that almost all young people with proper interventions and support can be rehabilitated to not recidivate and commit these very serious crimes. So of course, I'll tell you right now, based on what I do, I believe kids can be rehabilitated. So I litigate whether or not they should be sent to adult court, where oftentimes their sentences are going to be the functional equivalent of life sentences, or whether or not they should be rehabilitated here at the local level. I also work with our, sorry, my dog hears something. Riley. I also work with the juveniles that have been diagnosed with serious mental health issues, and we do a lot of work with getting them diagnosed, and if we can, getting proper medications for them, and getting proper interventions in place for their families so that they know going forward what would provide, pretty good interventions so that hopefully those kids don't have to see us again. So I think I've talked for quite a while now too. And I at this point could open it up, give it back to Sarah, or open it for questions.
I would just like to thank both you, Julie, and Sarah, for your really informative presentation. So much of that information was really helpful. I think this is an area that so many of us are curious about and concerned about, because we do as an organization really care about the welfare of children. And yet there's so many things that we don't know. I don't know if Sarah has anything to add before we go into Q&A. I know I've got a couple of questions, and then we've got one or two in the chat.
I'm open to questions if anybody has any questions.
Excellent. So let's start with this one. There seems to be better options for kids under 395. Are there shortages of lawyers, social workers, emergency foster care under the system?
Yes, there are shortages in all of those areas. For each county was given their own way of implementing 395. LA County had a phone. I don't know if they're still running it or not, but when it first came into effect in about 2018, they had a phone that they were handing off. Each lawyer would have it for maybe 1 week at a time. And then their compensation was that they would get a comp day at some point in the future for running their 24/7 phone for that week. I don't know if that system is still in place in LA County. In our county, it's basically just me. I'm on it 24/7. And that's okay, because my other responsibilities at the office are reduced, and I have fewer people to supervise because I run the phone. So we've been able to do it that way. But in terms of shortages of social workers, 100%. We need more people to help. Once we get the intake calls, then the next step is connecting with the children and making sure that they get all those services, because the services are going to be the things that help reduce their recidivism, reduce the potential that they come back and see us again. We want to be able to, when they come into the system, that we rehabilitate them, that we provide what we call wraparound care, wraparound services, holistic services to address each aspect of their life that is interfering with their ability to basically to avoid law enforcement contact.
Thank you. I'm going to allow one of our attendees to, I think she's got a question. So
Okay.
you want to ask? All right. Well, Jerry, you've got your hand up. If you want to talk, you can. I've got a question. So in your opinion, what kinds of circumstances would make you feel like it was appropriate for a juvenile to be tried as an adult? I know that might be kind of broad, but if you've got anything there.
I'll let Julie handle that one. I'm going to mute while she talks.
That's a good question, because I haven't seen one yet. I can tell you that nobody ever comes to meet with Sarah or myself professionally because everything's going well in their lives and they're just out committing crimes, just with no consideration for the people in the world and society. Everyone, I have not, I know it happens, but I have not yet had the juvenile client that just had a bad day and is perfect in every other way, and they just decided they were going to go on a crime spree. I can tell you I've only ever represented a lot of foster kids that are noticed for transfer. A lot of kids who's they're with older people who are saying, hey, you take the gun, you do the thing, they'll go easier on you. Kids in gangs. But if you look at why a kid joins a gang, and if this kid could be pulled out of that environment, they wouldn't be in the gang. They'd be doing something else. I mean, I can tell you most kids would much rather be doing something other than being in a gang, because it would be more fun for them. But so I'm going to tell you, I don't know if this is the best answer in the world, but I haven't seen one yet. But I will tell you the kinds of cases that do get transferred and get noticed for transfer in our county are multiple robberies and homicides. So kids charged with murder are the ones that are getting noticed right now.
I'm just going to add real quickly to that. Basically, what I'm hearing Julie saying, what I agree with, is that there's a multitude of factors before a kid commits a crime. There's typically a breakdown, like they've been let down by parents, guardians, schools, other support systems in the public have not met their needs. And so over time, they have become frustrated. They don't have boundaries. They have nowhere else to go. So they might be on the streets or they might be in a gang. We have seen that there's a lack of team sports, for example, in a lot of communities. And if you have parents who don't have the money or the time to pay for a travel ball sport, for example, or to pay for extra sports, because the schools no longer offer those things free of charge in a lot of educational districts. So without group activities, without teams to belong to that kind of keep those structures, those boundaries in place, we're seeing kids who just have time on their hands and they've just been let down by so many other systems. And I feel like we could do a better job as a community by getting more sports back. And I use sports as one example, but it could be speech and debate or theater or any type of group activities that really help kids connect with each other. Because when they connect with each other, they start to see the humanity in each other and they start to have other things to do with their time, like their after school time. I can tell you, I get more calls on the phone when school is out, like 4 o'clock, 5 o'clock, 6 o'clock. And then the calls that come in at 8 and 9 are typically investigations about things that happened in that time slot right after school.
And can I actually dovetail on what Sarah said? So one of the things that, I work in my microcosm of the world, but this is the League of Women Voters. So you guys are, we as citizens vote on policy choices for our state. So one of the things when you're looking at whether or not when you're thinking about voting and things like that. So think about okay, so you're going to transfer a kid to adult court where they're going to look at this huge, they could be looking at 50 to life, 60, 70, 100 to life. That's the functional equivalent of a life without the possibility of parole sentence. So, but what we know is that it's highly likely that they're going to age out of committing crimes. Almost all people age out of committing crimes, and it follows the brain maturation curve. So kids that are getting in a lot of trouble it seems like they're going to just go straight to jail. They're actually going to mature out of it by the time they're, in between like 25 and 30, they're not going to be a problem anymore. So if you know that this person's probably going to age out of it, do you want them to be incarcerated? Because it's really expensive to incarcerate people. Or do you want to try and rehabilitate them sooner? So you front load on your time and your effort and your work. But these are all policy considerations that you think about. And people are going to go different ways on how they think about this. But also, if you're paying for all these people to be incarcerated, there's only so much money. So you have to think about where you want to put your resources and where you want to position your resources. And if we think we can rehabilitate the kid, then, what do you want to do? Do you want to pay to put them in an adult prison, or do you want to pay to try and rehabilitate them?
Thank you.
Thank you.
I really appreciate that's all so valuable. Here's a couple of questions that are a little bit similar. And they have to do, so our league covers both San Bernardino and parts of San Bernardino and parts of LA County, and many of us live in LA County. So this comment/question is that it sounds like San Bernardino County is working more positively towards replacements for juvenile halls. And also, are there suggestions that you have for things that LA County could or should be doing? So there's that. And then on the juvenile halls, I had a question about what are some of the functional differences between the kinds of places kids were being put and the new places? That's a lot. So if you need anything repeated, let me know.
All right. Well, I just want to address quickly the differences between San Bernardino County and LA County. I don't really want to speak on that so much because I'm not as familiar with all the programs LA County is running, and I don't want to misquote something or misspeak on something. I do know that the Public Defender's Office in LA County is heavily invested in juvenile law. And in fact, we're one of the agencies that spearheaded the 395 calls happening. So Senate Bill 395 is heavily, it owes a ton of gratitude to LA County Public Defender's Office and the individuals there who went up to Sacramento and testified and brought it to the legislators' attention of what was happening to our kids if they weren't given access to counsel. But with regard to their programming after they come into the system, that I don't really know what the county is doing there. And as far as the functional differences in placement and housing options, Julie is much better equipped to answer that question. So I'll turn the mic over to her.
So as far as LA County is concerned, again, I don't work there, but it's the LA County, it's the probation departments that are responsible for running the new secured youth treatment facilities. And I can tell you what worked in our county that I think can be replicated anywhere. Our county sat down with the stakeholders and internalized the idea that it's our job now. And these kids are being paroled into our communities. These kids are going to be my neighbor. They are potentially going to be down my street. And they are, because they're all going to be down, they're coming home. So you have to buy into the idea that you need to rehabilitate them, because they are going, if they're not going to your neighborhood, they're going to somebody's neighborhood. And it is your job. So our county bought into that. And all the stakeholders sat down together and they agreed that if we have to do this, let's do it right. That, I think that's all it takes, is that everybody internalizes the idea that it's important and it has to be done. And there's a lot of good work that can be done, but everybody has to really buy in. You have to buy in.
Thank you. This is kind of a comment, but I'm just going to read it and see if you have anything to yourself respond to. It's like wrong place, wrong time, yet the youth have to take all the consequences, and who are vulnerable, and those who are older might take advantage of them or coerce them. They need 100% rehab and to serve their time, but come out with a college degree. So this was a comment from one of our attendees.
I can say that in San Bernardino County's secured youth treatment, our equivalent of the CYA, they are able to, so our first generation of kids has only been there maybe a year and a half, but we have kids that have already attained an AA degree while in custody, and the probation department is forming partnerships with local four-year universities for the kids to get their bachelor's degrees. And there's a theoretical possibility that if a kid does actually stay till they're 25, that they could potentially get a master's degree while they're there. The kids that are in our treatment facilities, they do intensive therapy. And I will say, like 30 days after a kid gets sentenced to the youth treatment facility, the probation department sends information about the kid to all of the groups that work in juvenile hall. They come up with a treatment plan, and then we have a review every 6 months of how the treatment plan is going. We actually have office hours where we contact the kids every week to find out, like, are you going to your treatment plan? How's that going? But our county has been instrumental. So they've got academic tracks, but they've also got vocational tracks that the kids can work on. So there's all kinds of vocational things that they're working on. And then our county is coming up with a contract with a fire camp so that the kids who might be interested in fire service later can get started by going to fire camp.
Excellent.
I wanted to add one quick thing about some of the meeting of the educational needs of our kids who go just into the hall. Even the kids, we have more kids that go to the hall than a smaller percentage go into the secured housing that Julie's talking about. But educational needs are met at the hall, and there are some other laws that we can take advantage of to help our kids. When, for example, if a child has moved a lot and some of their academic records are difficult to obtain because they're in school in one place and then their parent or guardian moves them and doesn't enroll them in school somewhere else right away, and they have large gaps in education. Historically, a person to graduate high school needed a certain number of units to graduate high school, for example. The law now allows when a child has been to the hall, they are allowed to graduate with reduced amounts of credit. So they can still earn a high school graduation rather than a GED or equivalency type of certificate. They get an actual high school diploma with I believe it's a 2-year or equivalent of 2 years worth of credits. And we help the kids by collecting their credits to count, to see where they're at, to get them close to that 2 years so that we can petition their school to give them the high school diploma. So that is helpful for them to get into colleges, to get that high school diploma. And the other thing I wanted to address is that kids that go into the foster care system, then because they're in foster care, also they qualify for getting assistance with going to college, which is helpful as well. So diverting some of these kids from incarceration or detention, which is the word we use, detention at the hall, instead of going to the hall, but going into foster care has been helpful for helping get these kids into college placement.
So if kids just come from the hall, they don't get that same route to college?
Some do and some don't. It depends. And they do get assistance with from their probation officers, but it's not the same. It's under different grant funding. It's basically different pools of money, if you will. If they go in through foster care, they get services longer. If they're on probation, they get services through the probation department.
Great. So here's a question that hopefully will be a little bit lighter. Do you have any specific success stories that you might be able to tell or have permission to share from clients that you have worked with that the system has worked for?
I'll go first if that's okay, Julie. So I have 2 I can share off the top of my head. One was a child out in the Joshua Tree area, and teens being teenagers, they were out driving in the desert and they would do a thing called car surfing, where some teen would be driving and another teen would be on the roof of the car or the hood of the car surfing. And a particular kid died in this activity, which as adults, we could all see how dangerous the activity is. The children didn't see how dangerous that was going to be. And so middle of the night, I get the call, I drive out to Joshua Tree, it's like 3 a.m. And the whole, all of the kids from the school were there, all the kids that were involved in the activity were there. Everybody is crying. The child that I talked to, my client, he's in the back of a patrol car. But the success part of that is this. Number one, he didn't get arrested that night. He was not taken to the hall. We got him released to go home. We followed up immediately with social workers. We did what we call a biopsychosocial, which is a in-depth report that our social workers put together. They talk to the parents, they talk to the child. They can assess where they are in their developmental stage, where they are at school. We brought in report cards to show that this particular minor was on a path to do very well. His family had gone through a period of adjustment where his dad had lost his job and they had to move. I believe they moved out of their old home and into this newer place that they had in Joshua Tree. But because of our biopsychosocial, turned all that over to the DA's office, and the DA elected not to file homicide charges on this child. And I think that was 100% due to the efforts of my office and our immediate reaction of getting out there, making sure that nobody talked, making sure that there was no confessions, and making sure that we addressed the individualized needs of this child and presented what would be an individualized plan rather than just like a rubber stamp kind of plan of oh, this happens, so here's what normally happens as far as charges being filed. We were able to do an end run around it and no charges were filed on that. Another one I can speak briefly on is a young woman who I spoke with over the phone. And over the phone, she disclosed that she was a victim of human trafficking. And so based on that, I then went and drove to the station where she was held, talked with her again face to face, got her permission to talk with the officers about her human trafficking, because everything she and I talked about was confidential, but she did get permission to speak to the officers. They eventually got in a different group of officers to come and interview her about being trafficked. And it was gut wrenching. It was just hours and hours of testimony from her, or statements from her about the things happening to her. And ultimately, we got her into care, we got her into services, and she wasn't prosecuted for the crime she had initially been arrested for. And had we not been able to talk with her, she didn't feel comfortable disclosing her victim of being a victim of trafficking to the male officers who were arresting her for the underlying crime. But once she was able to speak with me, and once they were able to get female deputies to come in and talk to her with her permission, it went a completely different way. And so now she's in care.
I guess I have a story about also about a trafficking victim who came to me. She's a foster kid, and I can tell you that one of the things that foster kids are really at risk for is becoming victims of human trafficking, especially victims of sex trafficking. And this young person had been a victim of trafficking, and it got really bad one night, and she got picked up by a local PD, and she was ready to be done and get out of life. But she was on probation already for something, and we had to decide, should she stay with the foster care system or should she go into the probation system? Well, if you go into the probation system, in our county, you can either be foster or you can be probation, but you can't be both. So if she came over to the probation system, she was going to have to go to a probation group home for girls that is focused on delinquency, whereas her underlying crime for which she was on probation was directly linked to being a trafficking victim. And the probation department did not want to put her in a probation group home, and they were willing to die on that hill. And so we were able to find an alternative placement for her. There are some private groups that don't have contracts with any of the government agencies, and we were able to get her into one of those. And they do, they can do a very good job. And this was about 2 years ago. And last week we, and I say we, but all of the work that I do, and I think Sarah would agree with us, our partners are our social workers that work for the public defender's office. I think we are co-equal in the work that we do for our clients. So this young client sent us, she successfully completed probation and got her record sealed, but she also just sent us her graduation announcement. She's graduating from high school and she's about to enter nursing school. And she went from being arrested several times for trafficking to, getting the right support at the right time. And she's going to nursing school.
That's so fantastic to hear. Thank you for those stories. They're great. That is all of our questions. I'll just ask one more thing if from each of you is if there's one thing you could impart to this group of action we could take or something we could think about in this realm, do you have any parting thoughts for us?
Well, parting thoughts is, first of all, thank you for having us. I think that one of the things that is helpful is getting the word out on what is happening and how programs are being successful. And also that helps us, success stories help translate to funding dollars to replicate those programs elsewhere. We have programs with mentorship, and I do think mentorship is very, very important. And so as a group, supporting different mentoring type opportunities is important. We have a program with our juveniles in our county where the girls, the young women are able to go out of the courtroom once a month and have activities with the DA, the public defender, and the judge. So all of the female staff in court, the deputies, and any of the other staff in court are able to go bowling, for example, or we go take the girls to a movie, for example. And we have, and the women in this program have group therapy, they have the ability to talk one-on-one with a counselor. Some of them are in substance abuse therapy, but I think the ability to see professionals or people who they develop a respect for the judge, for example, or a respect with their lawyer when they see them at a personal event. So going to a movie, going out for birthday cake, going out for ice cream, going bowling are just some examples of those things we've done with the girls. And it shows them that there is another life and there can be fun moments. And then when we do have to, for example, sentence them on a violation or talk with them about restructuring something that needs to work out differently, they're more receptive. And I think they're more receptive because they have more respect for the system at that point.
I think what I would remind everyone is that rehabilitation can be accomplished. And when you're being asked to consider a program or a law that is implementing or augmenting a program or providing funding for a program, to remember and to think about and consider, investments in infrastructure and society. They look expensive on the front end, but they save a lot of money on the back end, and they save a lot of lives, and they save a lot of families. So, hopefully that could be a consideration for people when they are considering those choices.
Thank you so much. We have one last comment, and that's that the community needs to be involved in these activities. And I fully agree. This is part of why we do these presentations, so that our members and anybody that watches it knows more about what is going on and how we can impact these issues. I would like to thank you both for so generously giving of your time today, and thank everybody that attended. And with that, we will close this meeting. Thank you all.
Thank you.